No, I want to. I want to
study something.
I know I wanted to do something. I'm trying to remember what I wanted to do. Because everything I have the time table for what I want to do. I know I want to finish my thesis then I want to read. Okay, I want to read. And I can spend an hour.
No, first I'll complete the distributive system.
Okay.
Then you'll begin your
Okay.
format.
All right.
Then 1 hour maximum.
Okay.
A nejlepší je vlastně, jak ti tady typek dává prezentační dovednosti a má slajdy jako bych sám. To bych zaviděl.
Yeah, check. You need to change your. You need to change your. Change the system. You need to make use of.
Málo lidí šlo.
Where do these admin go to get this admin?
You create a folder.
Then if you borrow the book,
If I borrow the book, I
it
hope
goes to the next page.
it's working.
This is the interface.
I'm coming. Just hold on. I want to check.
No, she has to like back, one second back to the same book, so she has to change
I
that.
want to do something. If I click on click to view books, I need an header. Yes. I need an header list of books available for loan. Available for loan. Yeah. So when I click that, when I do that, when I click that, it should come here and add. Should come here and add. Should come here and add. So let me delete what I have in my own.
Have a backup and then
Okay, we even need to insert the book size.
Yeah, I want to check if it's really inside.
When we need to
I don't think I'm big enough. I was thinking it's next week. I don't
and maybe we can use more than 3 food slides. I was thinking of
Sorry about that. So it's up to you whether you want to reintroduce or just carry on the way you were.
I think, but I have an issue. I think you're going to pay for an extra.
Oh, we've got to pay for an extra. Yeah. Okay.
I'm taking it serious.
Yeah. Well, you know, we'll see how good it is. If it's worth it, then we'll pay for it. Okay. So we'll restart the clock as soon as there's about 25 minutes left. So that's fine.
Hi again, this is Marva. And now I'm going to talk about some regulations which concerns our case. The first one is, actually it implies on Major Expo, which is in front of public eye, is responsible for the disaster which happened. The first regulation is offshore petroleum activities, which is regulation 2005. It's an offense to make a lawful discharge of oil. However, Major Expo can get out of this issue if they could prove that it couldn't have been prevented, or they did that urgently because they wanted to secure somebody for the safety reasons. But it doesn't really matter in our case because we're really concerned about deep water. The second regulation which concerns us is duty of care, which is a common law. Everyone has a responsibility to do their job properly at a professional level to ensure that they don't make any harm or loss to any other person. If that found to be breached, then the supplier or who done the job has to compensate the victims for what they did. There is a case about this which is called Bazius Neal case, which was that lady who was sitting in a cafe and she had a ginger beer, and after she had a bottle, she found this. After she finished her bottle, she found a snail in the bottle. And she felt ill because of that. So she sued the manufacturer of that ginger beer, and she was compensated for that. And in our case, Major Expo expects us to provide that we provide them with a good software, so we have a so if anyone entered a contract, they will be sued on the contract. In our case, every software has a contract, and there must be an acceptable error in each software, which will be explained later by my colleagues. Now let's move to another law, which is one of the internal issues of the company, and we should be aware of, which is the defamation law. It's the Act of 1952 and was updated in 1996, which is any false statement made by any person about someone to other third party, and that statement would harm him in any way, and harm in any way. It could be spoken or written, published, called libel. And the person who claims to, in this case, sue, could not just blame Justin for what he did because he did a whistleblowing on Facebook and blamed her for what happened. She also can sue the company, which is the deporter. Deporter because usually they run after the person who has got the money, who has usually they sue the companies because they got the deep pockets. She can sue the company for defamation under the vicarious liability law, and I'm going to, which is part of the employment law. Vicarious liability, anybody would be blamed for something he didn't do, and someone else did. If they have a legal relationship, like a husband and wife, parent and child, owner, vehicle and driver, an employer and employee. So in our case, Sue could just deport her for what Justin did, if they could prove that he did that during the working hours. So if we want to stay away from this problem, we have to prove, first to prove it's not true, that didn't happen, or we have to prove that it didn't happen during the working hours, which will be explained later by my colleagues. Now I'm gonna pass it to Abhijit to talk about contracting policy.
Hi everyone, I'm Abhijit here. Now I'm going to just talk about the basic contracting policy, policy and the rules and regulations followed by the two concerns when the starting venture. The time duration of the project, it's like the Deepwater and the Major Expo, these two companies, they just sign a contracting bond stating the time duration of the project, how long it's going to work. And the second thing is the responsibilities between the client and the developer. So while in the project, there are responsibilities for both the client as well as the developer. So like for example, if you're not going to just let out the codes and rules and regulations that have been given by the client and decide all the formats the outside for all remaining competitors, satisfying the actual design by the client. So it is every developer's duty, to just state that satisfying what all the client has prescribed in the contracting policy. The policy that is needed to be followed on the course of creating project. So what are the rules and regulations that has been posted by the the major Expro, the company over there. So it has to be followed by the deep water solutions without, strictly following it. And strictly following the codes and ethics, that even comes under the same thing. Now the software is fully revised and tested before submitting to the client for the final showdown. It's every man's developer's business that it has to be checked, duly checked, before submitting to the project to the department concerned. Now publishing the system reports, solved bugs while testing, and a clear statement about the failure rate. So while performing the project, even the failure reports, everything has to be submitted to the proper concern. So in later ways, they won't have a problem of questioning like what went wrong and when it went wrong. Now, I'm talking about the whistleblowing policy. What is whistleblowing policy? It is an informant person who exposes some kind of a problems in the organization and who tries to resolve it. Now, this is actually the meaning of a whistleblower policy. So, according to internet, everything I just found it like whistleblowing encourages and enables employees to raise serious concerns within the council rather than overlooking a problem or blowing the whistle outside. Now, here in the internal case between the Justin and Stu, we have to make sure that whether whistleblowing policy is helping the Justin in this case. Well, there are certain policies that are widely followed in the whistleblowing policies to encourage you to feel confident in raising concerns and to question and act upon concerns about practice. So here, we have to make clear statement that whether Justin has followed this policy before the problem arises, before the oil spill. No, but these policies should be followed in the period of the contracting policy, not after it. Next, to provide avenues for you to raise concerns in confidence and receive feedback on my action taken. There are certain concerns. Only in certain concerns of the organization has to be told by everyone. Not the complete structure of it. And to ensure that you receive a response to your concerns and that you are aware of how to pursue them if you are not satisfied. And the final statement is to reassure you that you will be protected from possible reprisals or victimization if you have a reasonable belief that you have made a disclosure in good faith. So only when if an employee can be saved only when these policies have been followed and strictly if suppose anything against this, anything is breached on this, so it's unfortunately that we can't the organization can't help the employee to just move further regarding it. So now I just pass on to Sammy to just talk even deep about the legal implications that happen in the whistleblowing policies and the remaining procedures.
Right. Just like I mentioned at the beginning of the presentation, the objective is to steer deep water away from any legal implications. Now, the kind of proof that we're looking for is duty of care. We can get out of a legal case if we can prove somehow that reasonable skill and care has been used, such as what Marwa also stated as well. And also there has to be an acceptable failure rate, which should have been mentioned in the contract, which I'm going to discuss the kind of documentation that will require as evidence in a court of law. The second side of this legal case, the defense against vicarious liability, there has to be in place some sort of a company privacy policy, confidentiality agreements, that sort of stuff. Just like when you have a like health and safety training just before you take employment in a company, likewise there should be some briefing about the company's policies in that case. And also we need to prove that Justin's action was not in representation of the company. So I'm just going to take you through some of the documentation that we're going to be needing. First of all, we'll be needing the company software development policy and procedures. We need these as documentation, the service level agreement between ourselves, Deepwater, and Major Expo. We need a statement of compliance with a significant level, acceptable level of error. You can't say 100% safety, but you can have a percentage, it could be 0.001% error or potential error, but there has to be some sort of testing and procedure, audit trails. It's not like you just develop software, here you go. There has to be some sort of testing being done, some reporting, some audit trail, a bug list of the kind of bugs that existed and how we resolve them. there has to be communication evidence between Justin and Sue. Now, Justin's claiming that he did warn Sue about some problems in the way that the software was being developed. She can deny that, so he has to prove that. There has to be some sort of written evidence. And like I also mentioned, we need a confidentiality agreement in place from the company or some sort of employment contract. We need to review that to identify whether Justin action was done on behalf of the company or on an individual basis to get you out of the vicarious liability. Like Marwa said about a vicarious liability, usually someone like Sue would go after the person with the money, and in this case it would be Deepwater who should be going after. Now what I'm going to do is I'm going to pass you on to my colleague Mahmoud. He's going to be talking more in detail on legal responsibilities. Here.
Hello, I'm Mahmoud. So actually I don't have much to say because most of my colleagues have already said everything regarding the legal aspect. But we know as a consultant, we're being here to find a solution after being the problem, because there is a problem in the company. So we need a solution. So I want to highlight something, that is the responsibility that the company was supposed to have, that is in the legal perspective and ethic perspective. Let me start with the legal responsibility. So the legal responsibility, I think, first one, that is merchantability for a purpose. That is, there are legal repercussions against the software publisher for a faulty document if the software does not function as the document said it will. So the liability law, that is the software company can be held liable for damage in cases where there is implied warranty for information, defective product, and civil liability or expert source. Then the contract law, that is the end user, which Abidis have already said that on detail. So regarding the ethical responsibility, the company, each and every company, what they are looking at is what? To maximize their profits and what? To minimize their costs. So the business, that is the heat, that is, these include the managers, CEOs, team leads, financial officers, and others, or anybody that involved in creating that software. So it has to play a role. Each and every of them has its own role. So therefore, it has to play some responsibility to ensure that the quality product is created. So from the developers, that is, the developers need to understand the requirement that has been given to them, how this software will function. This is what we need. That is from the support and testing. That is support given to the users after they have the software can be what makes or break the case of legal responsibility. That is, good support ensures that you're going to have a good relationship with your client. So I think then the responsibilities of Justin and Sue, because already my colleague already said a lot of things. What I want to add from the ethical and legal perspective, that is, it is unethical and irresponsible to publicly release sensitive information, that is such as software bugs. That is what Justin did. It's unethical. So then it should be communicated to the correct people and fixed. And a fix should be implemented, because when we say ethical, communication is very important. So the more it passes, the more we have information, the more of the people of the group have that information, the more the problem will be released. So she should have notified the top management at the right time, that is at the beginning of the project. She should have done that instead of doing what she did. So I think Sami will give the legal references
Well, these are just some of the legal references before we go through questions and answers. It gives you an opportunity to ask us some more questions to elaborate further. I hope you've enjoyed the holistic approach of this case, and this is now your opportunity to ask your questions. So, thanks very much.
Okay, thanks. So I guess my starting point really is to ensure our liability is minimised, and I'm intrigued by this, I suppose, a slight juxtaposition, if you like, between the idea that we might publish a failure rate at the same time as the law for liability is saying that we are legally liable for any failure. So how does that work in practice? How would these two things marry up?
Well, we need to be completely honest and transparent in the way we're developing the software. There has to be some sort of a plan in place, how we've solved some of the bugs, or all the bugs as much as we could identify, as well as like what Mahmoud was saying, how we support the client later on. So it's a long-term process. So we're always monitoring the software, how it performs in the field, and trying to eradicate as many problems as possible. Obviously, you cannot guarantee 100% success. You can always say, well, we can guarantee 99.99% on the test that we've performed, it's functioning. So it has to be a continuous process, not just like, we developed software, here you go, just can run with it. We'll continuously have to improve.
So let me add to what he said. And in the support, during that support, you can be able to have some record. Maybe this software is functioning well. So when this issue arises, because they want to sue the deep water, we already have the document that our software is functioning as it's supposed to function. So this is not a software problem. Maybe they want to put us so that solve some of their problems.
Okay. Now, how do we know that this problem wasn't the client's problem? It may have been a misuse by the client of the software. So what could we do to try and put some of the responsibilities back onto the client?
Well, we have to first of all identify that it wasn't our problem, it wasn't a software failure, and we need to then claim that we've done duty care, just like what Mara was saying. We've performed our job to the best of our ability. It's acceptable by the law, and then it will be back to them again. We'll be completely eliminated from the case, and it could be a hardware issue. Just in the case with BP, the Deepwater Horizon, it was to do with what you looked at that, Mahmoud. It was to do with the mechanics.
Mechanics problem, yeah.
Yeah.
Okay, so internal to the company then, you, Avi, I think you were the one talking about what
Justin and Sue.
about Justin and Sue, and Sue having to notify senior management. But as project manager, do you not think her responsibility was to manage this, to manage Justin's activities and comments?
Yeah, but I think what happened actually is like Justin, he just gave a word about regarding this, but not through any emails or something in a written format, so that he can just in the later on where he can just claim, stating that I have mentioned in this way. But Justin has made and he posted on the Facebook after the issue happened, actually after the oil spill. So it's like it's a problem of a defamation. What Marva spoke about that. It's like Sue has to if he's rich enough to just pay for the compensation or something, or else he can even have rights of just suing the company too. But now the case is all about an external office thing. So for now it's like it's paused.
I suppose that what I'm trying to get at is it's very difficult, I guess, as a middle manager to know about what the right time is to escalate something to the next level, because it's your job to manage this project, so you don't want to be always taking problems to the next manager. Shows that it might imply that you're not very good at your job if you're always doing that. So how do you judge between these two things? How do you judge between
the first main thing, what managers have their mind isn't like what happened, what is written, what is the code of conduct that's followed by the contracting policy. So Stu was very keen on just finishing the project on the date what is being mentioned. So, and you know, it was the first time like they are just following it up. So it was in the process of following again and again. So she wasn't taken a further way of moving forward.
Can I just add? I mean, I strongly believe there is a claim of negligence here on in the case of Sue, and unless she can prove otherwise, unless she can prove that she followed the company procedure to the letter, because she should have taken this matter very serious if what Justin claims is true. So she should have taken a step. However, Justin as well should have, before going public with this, he should have spoken to a higher manager above Sue. He should have sent out an email to directors of the company even and say, look, these are the issues I'm having with the company. There has to be a procedure, a policy and a procedure in place for the company for employees at any level can approach any board director.
I think that's my questions. Any other questions anyone's got? Those of us left? No? Well, thank you very much. So let's thank them. Especially managing the interruption. Well done. So let's have an informal chat about this case then. So what's the what's your take on it now you've investigated it, and what do you think the issues are for the company?
Well, we haven't seen any documentation. We haven't seen the service agreement or anything. We haven't seen any employment contract to identify any of this. So the company should have a lot of evidence in place. There should be a lot of documentations for them to get out of this case. And if you've got those documentation in place, then absolutely you can completely get out of this case.
So what lessons do you take from that for yourselves going into work, into professional lives?
Would you like to have a go? Well, I think...
No, you're right. Let what I speak.
Shall I?
No.
That we should document everything, every step we do, we should document it. If any problem happens, especially in this serious case, it's not something easy. It's harmed environment and everything. We have to report immediately, not just wait until the disaster happens.
Proper, training should be in place by the company just before you start employment. Just like you have health and safety, you probably would have training on confidentiality, privacy policies, other sort of training. So then they have to sign some sort of contract that they've actually understood everything. Then you can hold them liable as employees and take actions against them.
So I guess from my own experience, it's very easy to work along in a project or in any situation where you recognise the problem and you're trying to deal with things informally, and at some point the disaster happens. Something happens, and if you've not done what you've just said about documenting things and being clear about things, then actually you can be left quite vulnerable, because there is a natural tendency then to seek evidence. And so whilst I don't think you'd want to be necessarily writing a daily log of everything you've said and done, but I think where there is something that potentially is serious, or where you are identifying something, you would probably want to take notes. You might want to log that by sending an email, so you have that as some sort of evidence that you've said it, or you might want to get it agreed as a minute or whatever, so that we can all accept that this is a decision the company has taken, the project's taken, and I've had my say. And you're right, you probably wanted to escalate it if you were still worried. If you were Justin, you'd probably want to be escalating this. But that's easier said than done. Particularly as somebody fairly junior in an organisation, you might feel vulnerable, and you might feel that exposing yourself like that could be a problem. And that's one of the reasons some of these policies about confidential release of information is important. And working to a contract is also important. We were doing some work here for a company, and they kept challenging our work, but we just kept going back to, look, this is what your requirement was, this is what the contract said, you know, we've done what, oh yeah, so you did. And then if that wasn't right, which it wasn't in this case, you know, we just said, well, that's fine, we're happy to fix it, but this is what you've told us, so we'll now tell us what the right requirements is and we'll fix it and we'll charge you for doing so. So there again, you know, being clear at the outset of the contracts, particularly delivery of software, is really key. But difficult to do because a lot of grey areas. So. Any other questions or points? Any thoughts about this case, or you know, if you were in this situation?
Well, how confident do you feel to be after, I don't know, several days of background research? It's not too much, and you delivered quite a legal-oriented presentation. How confident and competent do you feel to be after several days?
About getting
Yes.
deep water. Well, I mean, I draw my inspiration from great people. I believe that Henry Ford once said, "If you believe you can, then you can. If you believe you can't, then you can't." So whatever you conceive in the mind manifests into reality. Now, I believe that we can get out of this mess because if we have sufficient evidence to prove so, then there's nothing that could be held against us. We would not be liable for any legal action if we have our paperwork correctly documented, like what we previously mentioned.
And that, I suppose that reflects back on why some of the things we teach in courses around process, project management, that type of thing, are important. You know, they may not seem important at the time, but they're important of part of your professional practice and making sure things are evidenced, particularly if you get challenged later. Okay, good. I guess a piece of informal advice. One of the things that I didn't quite get from your presentation, slight illogical flow. So you might just, in terms of reports, are you going to pick the same slots, or have you decided to divvy it up a different way? Or because I think there were 2 bits about contracts, and then there was 2 bits, one about defamation and whistleblowing, which sort of I would have thought those were better together.